The Privileges or Immunities Clause by Akio Reed Amer and John C. Harrison. In 1865, after the defeat of the Confederacy, the former Confederate states formed new city governments, through which they hoped to restore the relations with the Union. Although slavery was abolished, the new governments retained racially restrictive voting rules and restricted the free slaves in many of the rights of ordinary life, like those related to property and contract. Other fundamental freedoms, like the right to speak freely and worship freely, were also widely restricted by postbellum Confederate states, much as they had been restricted by the states prior to the Civil War in cases involving whites as well as free blacks. In December of 1865, senators and representatives came to Washington from those states to take their seats. The Republicans who controlled Congress refused to seat members from the former Confederate states and formed a joint committee on Reconstruction to address the standards of those states in the Union. In the spring of 1866, the Joint Committee proposed a constitutional amendment that included a number of separate provisions. After modification on the floor of the House and Senate, that amendment was proposed by Congress in the summer of 1866 and ratified at the 14th Amendment in 1868. The Privileges or Immunity Clause of the 14th Amendment was a part of the amendment proposed by the Joint Committee on Reconstruction. The reference to privileges and immunities of citizens use the words of the provision in Article 4 of the Constitution, providing that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. The relationship between the two clauses is one of many subjects of debate, in part because the meaning of the provision in Article 4 was itself a subject of dispute when the 14th Amendment was drafted. Although other provisions in the Joint Committee's proposal were amended in the House and Senate, the Privileges or Immunity Clause emerged from Congress as proposed by the Joint Committee. In the congressional debate, the clause was regarded as an important part of Section 1 of the amendment, but debates focused mainly on Section 2 and 3, which dealt with issues of political power. According to the Supreme Court cases, privileged immunities that no state shall abridge include only a limited number of legal protections related to distinctly national citizenship as opposed to state citizenship. In the court's view, the basic legal rights of private law, like property, contracts, and family relations, are not associated with the citizenship of the United States as such. Rather, those rights are associated with state citizenship. Nor, according to the court, do the rights of national citizenship include the protections of the first 8 amendments, insofar as those limitations might apply against states as opposed to the United States. Although the court was found that the 14th Amendment does apply most of those limitations to the states, in its view, that result is not accomplished by the Privileges or Immunity Clause. However, in various concurring and dissenting opinions, several members of the court over the years have emphasized the importance of the Privileges or Immunity Clause as one key ingredient or the key ingredient in applying against state and local governments various rights mentioned in the Bill of Rights, such as the right to speak and worship freely. The court has found some rights of national citizenship under the clause, like the right to travel from state to state and establish residence in the new state. Ever since the 14th Amendment enactment, lawyers, judges, and commentators have argued that the clause means more than that. One debate is whether the privileges and immunities of citizens of the United States include the protections of the Bill of Rights, especially rights of speech, press, religion, as applied against the states. Another concerns the clause in application to basic private rights like contract and property that were important elements of set of rights known as the civil rights. Those who believe that the clause imposes some restrictions on the states regarding civil rights generally take one of two approaches. One of two approaches, according to one view, often called substantive. The clause mandates the citizen enjoy certain legal advantages such as the right to contract. Proponents of this interpretation often say that the states may regulate privileges and immunities but not take them away, and so must regulate them reasonably. According to the other way, the clause requires equality or non-discrimination. On this interpretation, to breach one citizen's private law privilege or immunities to limit those rights relative to those other citizens. As long as all citizens have the same property rights, for example, it does not matter what those rights are. The central historical example of an equal law from the framing of the 14th Amendment is a black code, the kind of racially discriminatory restriction of the private rights of free slaves enacted in many ex-Confederate states immediately after the Civil War. If the equality-based reading of private law rights is correct, the privileges or immunity clause perform much of the anti-discrimination function that is largely attributed to the Equal Protection Clause in the Supreme Court's doctrine and the accompanying account of history. Similarly, privilege or immunity clause is in fact the true basis for applying most of the Bill of Rights provisions against states and local governments. The clause performs much of the fundamental rights function that is largely attributed to the Due Process Clause in Supreme Court case law. Matters debate. The first perspective, Equal Civil Rights for Citizens by John C. Harrison. The privileges or immunity clause of the 14th Amendment operates with respect to the civil rights associated with both state and national citizenship. The clause refers to the privileges and immunities of citizens of the United States, and Section 1 of the amendment also makes citizens of the United States citizens of the state wherein they reside, thus ensuring that the individuals who are citizens of the United States will also be citizens of the state if they live in one. Privileges and immunities of citizens are civil rights and understood in 19th century legal classifications. They are the basic rights of ordinary life, especially owning property, making contracts, and forming domestic relations, but do not include either political rights like voting or special legal benefits like a franchise granted by the government to private people, primarily to advance the public interest. Classify many 21st century government benefits as between civil rights and the special privileges often present difficult questions concerning the application of old legal concepts to new circumstances. With respect to the civil rights of state citizenship, the clause provides for universal equality. It can be paraphrased as all citizens should have the same civil rights because it is the equality rule. The clause does not dictate or constrain the content of civil rights recognized by state law. It requires that whatever those rights are, all citizens shall have them alike. Its drafters believe that such a rule for universal equality would forbid race discrimination with respect to civil rights. They thought that the post-Civil War Black Code enacted by the former Confederate States, which limited the civil rights of freed slaves, abridged the free slaves' civil rights by limiting them relative to those enjoyed by white citizens. This whole requirements for general equality entail limitations on the classification drawn by legal rules, like classification based on race, sex, and age, is one of the most difficult questions left to us by the drafters of the 14th Amendment. They deliberately formulate their principle in terms that did not refer specifically to race and so posed for themselves and their successors a hard problem. Because it referred to citizens of the United States, the clause also operates as to the privileges and immunities of national citizenship. In general, legal protections associated with national citizenship are immune from limitation by state law because the supremacy of federal law under Article 4 of the Constitution. With respect to privilege and immunities of national citizenship that limited states before the 14th Amendment was adopted, the effect of the clause is indirect but important. Although the states were bound to respect the rights of national citizenship before the amendment was adopted, the power of Congress to adopt legislation affirmatively protecting those rights was a matter of considerable controversy. Section 5 of the 14th Amendment explicitly authorized Congress to enforce the amendment, including the privileges or immunities clause. Congress now has authority to create protections for rights of national citizenship that it may previously have lacked. Determining the content of privileges and immunities of national citizenship that predated the 14th Amendment requires looking into sources of law other than the amendment, which refer to but does not itself create those privileges and immunities. Some federal statutes create civil rights and hence rights of national citizenship. The patent statutes do so because they provide for intellectual property, and property is a civil right. The clause does not, however, expand the legislative authority of Congress beyond what is enumerated elsewhere in the Constitution. It does not give Congress authority to legislate and to property and contract generally. For example, rights of the property and contract are civil rights, but they are associated mainly with state and not national citizenship because power over them is generally left with the states and not granted to Congress. With the existence of the national government as the relationship between that government and citizens of the United States produce some rights of national citizens a difficult question. The Supreme Court has stated that there are implicit rights of national citizenship, such as coming to the national capital to transact business with the federal government. Whether that is so depends on the content of national citizenship, a category referred to but not created by the 14th Amendment. Many support the 14th Amendment in Congress. The states believed that the privilege or immunity clause would impose on the states some or all of the limitation imposed on the federal government by the first 8 amendments. They believed, in today's parlance, that the clause wholly or partially incorporated the Bill of Rights against the states. Whether it did so is a difficult question. That it would do so was indeed widely believed. That conclusion is not easy to derive from the text, however, because it requires that there be rights of national citizens but for the clause would not limit the states. Squaring that assumption with the supremacy clause is possible, but requires some careful parsing of the text and the concept it uses. Next perspective. The Privileges or Immunities Clause, Americans' Laws Clause by Akil Reed Amr. Ask any American from the list of the most important super cases of the last century, and a certain canonical names are sure to follow. Gideon versus Wainwright, 1963, ensuring a right to counsel. Engel versus Whitehall, 1962, ending official prayer in public schools. Miranda versus Arizona, 1966, protecting the rights of the accused. New York Times versus Sullivan, 1964, affirming American commitment to robust free speech rights. For most Americans, these cases represent the core of our constitutional and in particular the power of the key protections enshrined in our Bill of Rights. However, strictly speaking, these cases are not Bill of Rights cases. As originally written and ratified, the Bill of Rights protect against abuses by the federal government, and not as was the case in each of the canonical decisions listed above against abuses by state and local governments. The federal constitution today reaches these cases because of an amendment ratified nearly a century after the founding, the 14th Amendment, and also authored by an important generation of constitutional innovators forgotten by too many Americans, the Reconstruction Republicans. Today, the 14th Amendment is one of the most powerful provisions in the U.S. Constitution. The Supreme Court has read it to protect a variety of rights against state abuses, both substantive rights like religious liberty and procedural rights like the right to a jury trial, those explicitly written in the Constitution like those in the Bill of Rights, and those that are not, like the right to privacy, those that apply in the political realm like the right to vote, and those that have nothing to do with voting like the rights of minors. Can a single sentence in the constitutional amendment ratified nearly a century after its founding really justify this robust body of case law, the 14th Amendment and the Bill of Rights? Let's begin with the Bill of Rights. The Supreme Court began to apply key Bill of Rights protections against state abuses in the late 19th century. Was this move consistent with the 14th Amendment's text and history? Written by Ohio Congressman John Branham, a crucial clause of the 14th Amendment reads, "No state shall make or enforce any law which shall abridge the privilege or immunity of citizens of the United States." In the 19th century, just as today, these privileges and immunities include key Bill of Rights protection like free speech. Even the infamous Dred Scott or Sanford 1857 decision, the most widely read Supreme Court decision of its day, recognized as much, referring to the Bill of Rights as rights and privileges of citizens and specific protection like the liberty of speech and the right to keep and carry arms as privilege and immunities of citizens. Bingham's privilege or immunity clause simply declared that in post-Civil War America, states would no longer be permitted to abuse its fundamental rights, and they do so often had in the pre-Civil War and Reconstruction era South. The centrality of these rights, especially rights of robust political expression, to the Reconstruction generation is obvious in the political slogan that helped launch the Republican Party. The driving force, the 14th Amendment, its very first presidential campaign in 1856. The Republican Party nominated John C. Fremont and explained to all Americans what the party stood for: free speech, free press, free men, free labor, free territory, and Fremont. The clause history confirms this reading when explaining his amendment. Bingham consistently tied the privileges or immunity clause to the individual protections enshrined in the Bill of Rights. And other key Reconstruction leaders, like the amendment's spokesperson in the U.S. Senate, Michigan Senator Jacob Howard, followed suit. To be sure, not every protection listed in the original Bill of Rights was a privilege of individual citizens. Instead, some were key states' rights protections. For instance, at its core, the First Amendment Established Clause was originally designed in part to protect a state's authority to set its own church establishment policy without interference from the federal government. Following the ratification of the 14th Amendment, it made little sense to apply this particular structural rights against the states. Therefore, when deciding which Bill of Rights Protection Court has as privileges and immunities for purposes On the 14th Amendment, interpreters must analyze each amendment and separate out its individual rights aspects, that is, an individual's right to free speech, from its state's rights aspects, that is, the state's right to set its own church establishment policy. Finally, the Civil War and Reconstruction transformed the core meaning for certain key Bill of Rights protections. Take the Second Amendment. Take the Second Amendment, for instance. And the founding, this amendment protected the collective right to bear arms in a well-regulated militia for purposes of protecting the American people against a centralized tyranny. However, by the time we, the people, ratified the 14th Amendment, the Civil War, a war won by a strong federal army over bellied states, shattered this original vision. Rather than requiring guns for purposes of mastering as a part of one's local militia, Reconstruction-era families, particularly African-American families and white Unionists in the South, needed guns in their homes to protect themselves and their family from local violence by white vigilantes. In the process, the Second Amendment's core meaning shifted from a collective rights addressing the threat of federal government's oppression to an individual right, an individual privilege of American citizenship, targeting state and local abuses. Beyond the Bill of Rights. While a certain key Bill of Rights provisions represent core privilege and immunities protected by the 14th Amendment, these capacious words cover some fundamental rights as well. For instance, they protect certain rights enshrined in other parts of the Constitution, such as the privilege of habeas corpus, protected against the federal government in Article 1, Section 9, while this privilege isn't in the Bill of Rights. It is a fundamental privilege of individuals protected by the 14th Amendment. The 14th Amendment also protects certain privileges and immunities that are not explicitly listed in the Constitution, like the right to privacy.